In the aftermath of a bruising and polarizing confirmation process involving Clarence Thomas, who had been nominated by President Bush with no consultation just 4 days after the great Thurgood Marshall had retired, I took to the Senate floor to speak about the Supreme Court nominating process. Senate Majority Leader, and he's my friend, Mitch McConnell, and other Republicans today have been quoting selectively from the remarks that I made in an attempt to justify refusing Chief Judge Garland a fair hearing and a vote on the floor of the Senate. They completely ignore the fact that at the time, I was speaking of the dangers of nominating an extreme candidate without proper Senate consultation. They completely neglected to quote my unequivocal bottom line. So let me set the record straight, as they say. I said, and I quote, "If the President consults and cooperates with the Senate or moderates his selections, then his nominees may enjoy my support, as did Justice Kennedy and Justice Souter." End of quote. I made it absolutely clear that I would go forward with the confirmation process as chairman, even a few months before a presidential election, if the nominee were chosen with the advice and not merely the consent of the Senate, just as the Constitution requires. My consistent advice to presidents of both parties, including this president, has been that we should engage fully in the constitutional process of advice and consent. And my consistent understanding of the Constitution has been the Senate must do so as well, period. They have an obligation to do so. And every nominee, including Justice Kennedy in an election year, got an up and down vote. Not much of the time, not most of the time, every single solitary time. So now I hear all this talk about the Biden rule. It's frankly ridiculous. There is no Biden rule. It doesn't exist. There's only one rule I ever followed on the Judiciary Committee. That was the Constitution's clear rule of advice and consent. Article 2 of the Constitution clearly states, whenever there is a vacancy in one of the courts created by the Constitution itself, the Supreme Court of the United States, the President shall, not may, the President shall appoint someone to fill the vacancy with the advice and consent of the United States Senate. And advice and consent includes consulting and voting. Nobody is suggesting individual senators have to vote yes on any particular presidential nominee. Voting no is always an option, and it is their option. But saying nothing, seeing nothing, reading nothing, hearing nothing, and deciding in advance simply to turn your back before the president even names a nominee is not an option the Constitution leaves open. It's a plain abdication of the Senate's solemn constitutional duty. It's an abdication, quite frankly, that has never occurred before in our history. Now, unable to square their unprecedented conduct with the Constitution, my friend Mitch McConnell and the chairman of the committee, and he is my friend, the senator from Iowa, Senator Grassley, they're now trying another tack. They ask, what's the difference? What difference does it make if the court has 8 or 9 members? No, I'm serious. Remember, they said they weren't going to fill any vacancies on the Circuit Court of Appeals for the district for 4 years. Remember, that's what they said? And that's not a constitutionally created court. The Supreme Court is. So let me make clear for folks who may be listening at home. What happens, and you students all know this, but what happens at the Supreme Court makes a significant difference in the everyday life of the American people. That by reason of a tie vote, the court will find itself unable to resolve significant legal issues presented by the case, end of quote. If that possibility becomes a reality in any given cases, the justice would have to announce that they cannot decide either way. They'll be left clearing the case from their docket or kicking it down the road to be re-argued under a new court when a justice is finally confirmed. Pressing controversies that prompted the court to grant review in the first place, many cases because of different decisions in different circuit courts, would remain unresolved. The issues the court believes were too important to leave in limbo are going to remain in limbo, suspended in midair. The framers designed our system to give one Supreme Court the responsibility of resolving conflicts in the lower courts. If those conflicts were allowed to stand, we end up with a patchwork constitution inconsistent with equal justice and the rule of law. Federal laws that apply to the whole country will be constitutional in some parts of the country but unconstitutional in others.